Hi, everyone. Welcome to the GMS DEI Committee's amazing panel called Know Your Rights. I'm Jennifer Smith. I'm the newest board member here at the Amazing Guild of Music Supervisors, and I'm also a music supervisor. If you are a music supervisor, we encourage you to join the Guild, as well as if you're not a music supervisor. Reminder, membership is reserved for music supervisors, but musicians, publishers, library owners, you can subscribe as friends of the Guild. You can receive our monthly newsletter, event invites, discounts, and a lot of amazing perks. Angela will put the link to join in the chat. Go for it, Angela. I would like to have a huge thank you to the DEI committee and especially Kelsey Mitchell for producing this panel. I'm happy to introduce Kelsey. Take it away.
Hi guys, hi everybody, thank you for being here. A reminder, this was produced by the DEI committee for the Guild. That's the Diversity, Equity, and Inclusion Committee. We're always looking for more ideas and submissions when it comes to the work that we do on behalf of the Guild. We do have our own email address now, and that email is, hold on, let me find it. DEI committee at guildofmusicsupervisors.com. So go ahead and email us any ideas you might have for future panels or events or initiatives. So on that note, I would love for the attorneys to go ahead and introduce themselves. Why don't we go ahead and start with Craig?
Hey everyone, I'm Craig Ackermann from Ackermann and Tilajef. I'm a plaintiff side employment lawyer, been a lawyer for over 22 years, representing workers and executives in all kinds of cases. I want to thank Kelsey for arranging this panel, inviting me to participate, and the Guild of Music Supervisors for having us. And we look forward to a lively conversation with several of my colleagues here.
Awesome. Maybe Tatiana, did you want to go ahead and introduce yourself next?
Yes, hi everyone. My name is Tatiana Hernandez. I'm an employment attorney. I'm licensed in the state of California and in Washington. I practice exclusively in employment law, representing victims of sexual harassment, racial discrimination, and wage and hour disputes in the workplace. And I thank you, Kelsey, for inviting us to this panel and everyone that is participating here today.
Go ahead, Aashish.
Okay, thank you very much, guys. I am also an attorney. I've been practicing for over 25 years. My specialty is class action litigation. Primarily, I've been engaged in employment class action. That's wage and hour litigation if you're not paid for your breaks or you're misclassified, things of that nature. An interesting thing about me is I am actually a guitar player. I have been playing lead guitar for 40 years. Before COVID, I used to play in a bunch of cover bands, just, doing 80s and 90s and pop music, rock. I, play guitar and fill in. My brother's a studio guitar player, and he's in Los Angeles and plays on a ton of stuff. And so I have a particular sensitivity to you musicians.
Awesome, thank you so much. For the people that are in the Zoom meeting, wanted to break it down. The attorneys are going to go ahead and do a brief presentation. Each of them are going to discuss different topics. And then from there, we're going to get into our Q&A portion. There is going to be an opportunity for you guys to ask your questions yourself. If you want, you can just use the raise your hand feature and I will call on you. If you are uncomfortable with asking your questions yourself, there is an ability to submit your questions anonymously. And that bit.ly link is in the chat. And I will be refreshing that. And I may not be able to get to all of them, but I'm going to try and get to most of them. And let's go ahead and get started.
Okay, thanks, Kelsey. So in terms of what we're going to chat about today, everyone, I thought we would start out talking about the commencement of employment or independent contractor relationship, what you guys should be looking out for, how to negotiate a good package, as well as maybe the back end, which is the severance. That's usually when people contact me or Tatiana or Aashish. After we talked about employment contract formation and severance sort of issues, Aashish is going to talk a little bit about classification. I know a lot of you are working as 1099s and W-2s. Aashish is going to talk some developments related to that. Then we're going to open it up. All three of us are going to talk about some of the COVID and pandemic related issues that have arisen with working from home, with leave issues, with reimbursement issues. And then Tatiana is going to take us home talking about issues in the workplace of gender equity, sexual, racial harassment, and those sort of things. So that's kind of an overview of what we're going to talk about today. So I'll kick off. Unfortunately, most people don't contact employment lawyers before they begin an employment or new gig as a contractor. They really should, because, unfortunately, by the time people contact us at the end, it's often too late, and the contract is filled with things that are biased in favor of the employer or the hiring entity. So I want to just offer a few brief thoughts on and tips on negotiating packages up front, and things that if somebody did contact us up front, the sort of things we would alert them to look out for, both practically and then a few legal points as well. So just in terms of, I think I'll kick off by just talking about what are the topics somebody should be thinking about when you are going to onboard at a new company, either in-house or starting a new contractual relationship on a new project with an entertainment company or a film or television company, et cetera. So I made a list of, these are kind of like the 6 or 7 topics that I would suggest that people think about and that should be addressed in the written documentation. So first and foremost, a person should be thinking about what are the duties that are going to be required of me, and how do I specify that or list them off in the contract, either the employment contract or the independent contractor agreement, because you want to be on the same page of what exactly you're going to be doing and for whom. And so the job duties or the specifics of what you're going to be doing is something that some thought should be given to that. Secondly, the term of the relationship. Is this going to be a 6-month project, a 3-month project, a 1-year project? Is it related to the length of the particular film? So the term, and that also relates to the issue of whether the relationship is going to be at will, which means you can terminate it at any time, and so can the company for any reason, or whether there's going to have to be cause involved for one side or the other to terminate the employment or the relationship. So the duties in the term. In addition, obviously money, how are you going to get compensated? But that's usually multiple components to that. Is there a base or an hourly pay? Are there bonuses? Are there benefits? Are there profit participation? And how is that language going to be described and locked in a way that protects your interests? Something that I think people should think about, but they rarely do, is what's called the golden parachute. Okay, a golden parachute is not something you want to jump out of a plane with, but what it means is that if you're terminated in a short amount of time after starting a new project, are you going to receive some gold? Are you going to be paid, because maybe you gave up other opportunities? I'm a big fan of the golden parachute, that if I'm fired without cause or my contract is ended without cause within a 3-month or 6-month period, I'll get a 3-month or 6-month payout as a severance. That's something I always suggest that people bring up. The time that you have leverage is before the project begins. Obviously, once you've started working, you have no leverage anymore. And surprisingly, very few contractors or employees, other than senior executives, bring up the issue of, hey, what happens if this doesn't work out? It could be because it's awkward, but it's something that's worth thinking about, particularly if you're relocating, particularly if you're giving up a long-term gig or a prior lucrative gig in-house. And I think the golden parachute is something that should be brought up more often than it is. And the way that I often phrase it is, if I'm let go without any cause, can I get some form of salary continuation or contract continuation to bridge me to my next position? Very reasonable, something people could bring up, but they frequently don't. Am I going to be W-2 or, sorry, go ahead, Aashish. You have a question?
Stop you there? Because this is an interesting point, because under the severance agreement, the normal rule of thumb that we have in the normal world is, let's say you put in 10 years at a company, and somebody comes and said, Mr. Desai, they're letting me go, but they're offering me a severance. Is it reasonable? Why don't you take a look at it? There used to be a rule of thumb that said for every year, you'd get a week or something of severance, right? So if you're there 10 years, you should get 10 weeks of severance. If they're 5 years, 5 weeks of severance. With gig workers and the way that musicians typically operate, they don't really have these long-term arrangements. So what do you do when you try to value what that severance should be?
Yeah, that's a good question, Aashish. I mean, we have music supervisors here, some of whom are going to be in-house, some of them are going to be working on different films or TV shows. So I think the way I think about it is, for me, this is only something that really applies if your relationship is going to end within a very short amount of time after you start, and for no fault of your own. And in those situations, I don't think if someone's working more than a year that a golden parachute is something that they're probably going to get in a negotiation, unless they're a very senior executive. So for these more temporary arrangements, you know, you might be, if someone's going to work in music on Game of Thrones for, you know, maybe it'll be one season, maybe it'll be multiple. If someone's going to work on another show, maybe it's just a one season or a one show affair. But the way I think about it is sort of how long would it take if things don't work out and I'm really screwed and they just get rid of me, how long would it take me to land on my feet somewhere else? And so I think, you know, starting out with, if someone, like I had a client recently who came to work for the Dodgers, who was moving from a team in New York. I was helping him on board over there. I said to him, I said, look, if they let you go within the first year, it was going to be like a 3-year deal. I said, if they let you go within the first year without cause, I think you should get at least, you know, you should propose a 1-year golden parachute. You get 1 year of, and they're not going to accept that, but they'll come back with 3 months. You can say 9 months, and then you'll settle on 6 months. And, you know, and that's what he has in his arrangement now. So after the first year, you know, I think it's not the same situation anymore. Things have worked out, and then it's more like a steady gig. But in that first year, particularly, he was moving cross country, he's moving his whole family, uprooting his life. You know, who wants to get fired 2 months later? And then you got the reload expenses. You don't have a position. So I don't think it's unreasonable to ask for a decent golden parachute. Kelsey?
Here's my question to clarify for our listeners, viewers, whatever one, Zoomers. This only applies to people who are W-2s?
You know, I think you could ask for it even if you're a contractor, but
Okay.
in terms of how frequently it's actually given or negotiated over, it's very, very common at executive level, VP and above, for W-2s within companies, including in the entertainment space.
Right.
Less so for contractors or 1099s, but it's not unheard of, even in a contractor relationship. You know, it really depends on the particular situation and what you're being asked to give up. I mean, if somebody's a contractor, but they've been working 5 seasons on a certain show, and now they're coming to a new project that may or may not work out, you know, that could be kind of the scenario where it might make sense to ask for something like that in their contract. Probably is not done. And then, you know, another thing is I've mentioned here is just dispute resolution. You know, how if things go, you know, don't go right, how is the matter going to be resolved? Is there going to be first maybe an internal resolution or a mediation? Is it going to be in court, in arbitration? Those are some of the points that I think are important on the front end. On the back end, just in terms of the money now, I want to give a few tips for people negotiating their new arrangements. So people are very shy about negotiating salary and compensation. They really shouldn't be, you know, but a lot of people are. And they sometimes ask me, like, how do I go about asking whether I'm getting paid fairly or getting the maximum that I should? So I just want to arm them with a few tools. There's actually a few interesting things. The California Labor Code has a provision, section 432.3, that allows you to request pay scale for any position or job that you're applying for. And by law, they have to give it to you. So the pay scale, this is something people rarely ask for, but they should. The pay scale would include the lowest and highest pay of other people in that same position that you're applying for. And if it's a position that has only one at a time, it would be what the pay was in that position previously. So you're allowed to ask for that, and they actually by law have to give it to you.
Other question, is that only for W-2s, or does that also apply to contracts?
So Aashish is going to get into all of this. It would apply to all W-2s, and it would apply to anyone who's misclassified. You know, so it applies only to employees or employee applicants. But a lot of people who are applying for positions that are contract may actually, and Aashish will get into this, may actually be employee applicants, because in California, he'll get into it, it's almost impossible to classify somebody now as a 1099 successfully if you're working on a regular basis for them. So
Can I jump in real quick? That is the nail on the hammer right on the nail.
Yeah.
This is precisely why you get classified as a contractor instead of an employee. The entire labor code doesn't apply to you. That's the problem. If you're an independent contractor, you're not an employee, you're not subject to any part of the labor code. So all these labor code provisions that we're talking about just wouldn't apply. And so you see now what the benefit is of classifying someone as an independent contractor. Go ahead.
Correct. And that's why a lot of companies like to do that, particularly in entertainment. I noticed that they do it. And they also hire a lot of people through agencies to try to avoid having people as W-2s. A couple other points just on negotiating. I think market analysis is really useful. It's underutilized. What I mean by that is talking to recruiters or other people in the industry, what are they getting paid? One thing, especially for women who are applying for jobs, it is not okay for companies to ask you what your prior salary was or what you were earning previously. That's now illegal in California since 2018. The reason it's illegal is because it entrenches societal discrimination, because women unfortunately only earn 70, 80% of what men earn. And so that's also 432.3 of the labor code sections A and B prohibit companies from asking about salary history and using prior salary history to set incoming salary. That unfortunately is honored in the breach. You know, most people don't know about that. A lot of internal HR people or recruiters, companies just ask about it routinely. And therefore, if you were undervalued at your prior gig, they just put you at that same level now. So that's now illegal in a number of states, including California. And the only other thing I want to mention on that topic is the new Equal Pay Acts that have come into effect in California over the last couple of years really make it a lot stricter and better for women applying for jobs. It's obviously illegal now and has been for a long time for companies to pay men more than women for the same or similar work. In the past, though, it was very hard to prove the same or similar test, and the burden, like if they had rationales for, you know, prior education or prior work history or things other than gender, it was kind of hard to prove your case. The burden's now shifted. So there's a presumption of discrimination if you have similar job categories and a woman is earning less than a man. Now the burden is kind of on the company to show that it's not discrimination. That's last couple of years, the new law in California, very helpful. So use recruiters, ask about the pay scale. You also have the right under the labor code for W-2s and for people who are misclassified to ask other people in the company what they're earning. You know, some companies have policies, we don't want you talking about what you're earning. That's not legal. It's against the National Labor Relations Act. It's against the California Labor Code. So protect yourself up front. And one of the things, you know, if you hire an employment lawyer up front or some kind of lawyer, you can do the good cop, bad cop thing. And I've seen this used in the past very successfully by executives where they'll say, look, this isn't really my thing. I'm still looking forward to this gig, but I do have this lawyer trying to protect. Would you mind if we have a quick conference call with you, the company's counsel, me and my lawyer? And then, you make your lawyer do all the bad cop stuff. You know, you tell him or her, you know, I want you to say these 7 points, and then you can throw the lawyer under the bus on 4 of them and say, you know, those other 3 I really need to keep. But so if anything's awkward, just blame it on the lawyer, use the lawyer, and use them as a foil. So a couple of other points on the severance issue on the back end of things to think about. You know, are they gonna, if for W-2 people, are they gonna agree that you can get unemployment benefits, especially during the pandemic? That was very significant without contesting unemployment. Are they gonna give you a neutral reference or a good reference, or agree not to disparage you for future gigs, for future employers? That's something that should be addressed in severance packages or when you're leaving a company or a relationship. And COBRA benefits, to the extent those exist. I know Kelsey was saying, unfortunately, that's not very prevalent, but if there is health insurance provider, things like that, COBRA and other benefits, are those going to continue? For how long? Who's going to pay for those? The new bill that President Biden just signed recently provides for 6 months free COBRA. And not a lot of people know that. There's government subsidized COBRA benefits if you were let go or your gig ended during the pandemic, and that's up to 6 months. Even a lot of employment lawyers don't know about that. So that's kind of a general overview of things to think about in negotiating a new contract, employment or independent, and some tips on topics to raise and just different tools that you might have. So with that, I'd like to hand it over to Aashish to talk about some of the misclassification issues and issues related to that.
Well, thanks, Craig. And I'll tell you, before I talk about that, I'll tell you just one point on this Fair Pay Act. And Craig kind of mentioned it and said, hey, this is a better act because it switches the burden of proof. Let me tell you what a big deal that is. I've got a case right now. It's in San Diego. It's a genomics company. And they had about 600 employees. And we claimed that women were paid less than men. By the way, the reason it's illegal to discriminate is because you have this implicit bias that runs throughout. And so, sorry about that. What ends up happening is that if you rely upon the work history of your prior employer, they maybe have used work history from somebody else that maybe hired people for whatever reason. They thought women wouldn't work as hard as men because they might have to, have kids or something, for example. These kinds of things permeated all the way through. In the old days, we would file these cases and we'd have to go hire an expert. So what we do is we got to hire an expert. They get all, in general, you get this, all the men's salary, all the women's salary, and you compare the two. And lo and behold, there's a percentage difference. And we get to say, hey, a woman is only making 88 cents for every dollar a man is making here. Well, that your expert's telling you that. Well, in the old days, they'd say, okay, well, prove that the reason they're making less is because this employer's discriminatory, because they have somehow discriminated against women. And we'd say, well, Hamada, you know, he said this there. We'd have anecdotal evidence. We try to get statistics. We try to get stories of this happening, that happening. Sometimes you win, most of the times you lost. Well, now the burden of proof is completely on the other side, and there's really no ways to disprove, you know, what the math says. And so when the burden of proof shifts to the other side, it makes all the difference in the world. It's going to be interesting to see how that kind of plays out. I know you guys are in the entertainment industry, so it would be very interesting to see how all of that plays out here. Let me talk about what happened with this independent contractor very quickly. And I know I'll open it up to questions, and we'll get to some other stuff. And I know Tatiana has something to say. But there was a case called Dynamics. And like most things in my life, for some reason, they all start out with a good trucking case. For some reason, I've ended up representing truck drivers, and all kinds of case law appears magically when this happens. A group of truck drivers sued Dynamics. They said they were independent contractors, or they said they were employees. The employer said, no, you're independent contractors. Well, that's a dispute like you'd hear any other. It ended up working its way all the way up to the Supreme Court because nobody could figure out what test we were going to use. There was one test under the wage order, and there was another test under a case called Barella, S.G. Barella. That determined who was an employee or independent contractor within the context of workers' compensation law. So it wasn't exactly analogous, but it was good enough to where people were trying to use it. Well, the Supreme Court, the California Supreme Court said, well, we're not going to use either one of them. We've got our own test that we're going to come up with. And that is, I think what everybody knows is called the ABC test. Now, why do they call it the ABC test? Craig, why do they call it the ABC test?
Tell us, Aashish.
I don't know. I guess because it's simple. That's the only thing I can think of. It's very difficult to comply with, but it's simple. They're saying, we're going to take all this convoluted factors and just make it a 1, 2, 3 simple ABC test. Okay, that will solve the problem. Okay, what are the 3 simple tests that we need to do? What are the 3 factors of the test? Well, number 1, the worker has to be free from the control and direction of the hiring entity in connection with the worker's performance, both under the contract of the performance and in fact. That means it's got to be under the contract and you got to really be doing it. It can't just be a wink, wink, nod, nod. B, the worker performs work that is outside the usual course of the hiring entity's business. Okay, that's the hard one that they have to comply with. In other words, this is the 3rd prong. You've got to comply with all 3, by the way. I'll explain that. The 3rd one is that the worker is customarily engaged in an independently established trade, occupation, or business that's of the same nature as the work performed. Okay, so that sounds simple, but how does it play out? Well, if you think about it, the first test, to control of the employer, that can be massaged. I always look at it this way. The first and the 3rd part of the test can kind of be massaged depending upon what you want to say. The employer can decide whether, how much control he or she wants to have. But the 2nd prong of that test is nearly impossible to massage. It says that you've got to perform work that is outside the course of the usually established type of work that the employer is doing. So here's a quick example. If you're in a retail store, let's say you're working at a retail store, and they go out and hire a plumber, or they hire an accountant, or they hire a lawyer, God forbid. Well, those types of people that it was hiring, that's not in the usual course of a retail business. A retail business is there to sell retail merchandise, and accounting isn't part of it. So that isn't part of their duties. But on the other hand, let's take a clothing store, for example. Let's say a clothing store hires a seamstress that works from home and then comes and is an independent contractor, but gives you the dresses, made. And the clothing store says, well, okay, then we'll sell that and we'll call this person our independent contractor. Now that person would not be an independent contractor. Why? Because they wouldn't pass that second prong of the test, because they are doing exactly what their clothing store is in business to do, which is sell clothes. So you can't then hire other people to do exactly what it is that your business is there to do. Now, all of this, as you might suspect, if you were to take a literal interpretation of the ABC test and apply it to many different businesses, it would create havoc. And so it did. And all the way from musicians to comedians to magicians to everybody else, particularly people who do not work traditional, what I would call a traditional job, 9 to 5, you put on a suit, you walk in. Those kinds of jobs were all up in the air because none of these terms made any sense within that context. And if you took them at their word, you know, quite often, if you're working in a symphony and the symphony is there to produce a musical performance, and you have 3 violin players, you know, some oboe players, you know, those people are arguably they're doing what it is the orchestra's there to do, which is play music. In that scenario, they would technically be employees under this rubric, the ABC test, and all the stuff that Craig talked about, every one of those labor code sections, what did he say? Labor code 432.3, you know, be sure to talk about that. All of that would come right in, come roaring right in. You'd be able to demand everything, pay stubs, overtime, sick pay, you know, pre-shift, post-shift, all the good stuff that has kept me busy for 25 years in California. All of that good stuff you'd be able to go sue for. Well,
Can I clarify something real quick?
absolutely.
So, I mean, according to these definitions, that means that 98% of music supervisors are misclassified because we are basically all 1099 unless we're lucky enough to be in-house. That's bad. We see that now. What you're saying is that once we leave the position, we can retroactively get what is owed to us by engaging an attorney like you guys?
Well, let me finish first.
Okay.
Because here's what happened. As you noticed, the world went ballistic here in California, and there were all kinds of arguments and YouTube videos and letters and, you know, opinion pieces in the newspaper about how this is terrible for the workers. I said, what are you kidding me? I've been fighting for this for a long time. Now you're telling me this is bad for the workers? Yes, it's horrible. They won't have flexibility, this, that, and the other. Anyway, what ended up happening is Governor Newsom got pressed so hard that in September of 2020, he ended up passing an amendment. It was AB 2257. Now, AB 2257 basically exempts a lot of occupations from this AB5 bill. After Dynamex, the big case I talked about with the truck drivers, passed, as soon as it passed, the legislature passed what everybody knows is AB5. AB5 codified the ABC test for everybody. It said all employers have to comply with this. So we said good and well, but then everybody complained. And so now the new AB 2257 says the law applies to everyone except musicians, comedians, magicians, songwriters, promoters, publicists, writers, photographers, copy editors, cartoonists. It kept going and going, you know. I mean, it's really something. It's one of the strange, it's a strange law where when I look to see if a case has merit now under this new rubric, I will first go to the exemptions and make sure the person that I'm talking to doesn't fall within these exemptions. Because if you do, they're going to be able to keep 1099ing you. That's the long and short of it. So what it did was it kind of saved this bill. There was a lot of press about how, for example, the gig worker, the guy like me who would go into a club and say, hey, I'm going to play 10 to 2. In my days, it was 10 to 2. Now I think it's 6 o'clock or 8 o'clock to 12 o'clock is the game, you know, for the guys going to come in there. We're going to do an 80s cover rock band. Okay. We're going to play from 8 o'clock to 12 o'clock, and we'll play Friday nights and, you know, Thursday nights. And if you like us, we'll keep coming back. Those kind of guys could have arguably been considered employees. And so as a result of that, they started arguing about how they couldn't take gigs. The orchestra, the LA, orchestra over here, like I said, they're in the business of putting on shows. Production companies are in the business of producing shows. So there were a lot of people with some vested interests out there. So at the end of the day, when it all came down, there is an ABC test. It applies to a certain group of people. Entertainers, by and large, have been exempted out of this.
Hold on a second. So I get what you're saying, that a lot of the music creators would be exempt. So they'd maybe be under the old test, or maybe they could still be 1099. But to get back to Kelsey's question, these music supervisors who are basically they're in charge of placing music on TV, what they call synchronization, placing the music on TV or other entertainment or within games. I took a look there at the statute. Are they exempt? To me, it doesn't look like they fall within those music industry exemptions. So Dynamex would apply. So getting back to Kelsey, wouldn't they all be able to pursue misclassification claims through PAGA for the penalties?
Here's what I'd say. Kelsey, are you in that capacity? Are you a musician?
No.
No. Are you a comedian?
Sometimes, no.
Are you a magician?
No.
Are you a songwriter?
No.
A promoter or publicist?
No.
Then it doesn't apply.
Yeah.
Okay? So, I think that you have to be careful. There are a lot of I think your point, Craig, is very well made, which are a lot of people ancillary to these groups of people who, just because they're in that environment, think that they're entitled to the exemption too. You're not. You got to be the actual musician. You can't be, the assistant to the musician who's, the cartage company bringing all the labor, and he's basically just a guy delivering items. So you can't say the cartage guy who's going to bring all my racks of, all my ADA processors and quad reverbs and all the stuff I need to play my gig. He's got to come out there and spend all day and tune them right up exactly the way I dial them up. And I've got a Bradshaw rig down here after all, and he's got to set that up. Those kind of guys would be in a different situation altogether. So go ahead.
Maybe Kelsey can help us out here. A lot of these music supervisors who are working sort of under 1099 may have people working underneath them too. Maybe Kelsey could tell us what kind of people they're hiring underneath them, because although we don't usually give advice to the employing entity, there may be some exposure there if they don't do it right in terms of who they hire. So Kelsey, what kind of people would the supervisors who are operating on contractual relationships with studios, entertainment companies, what kind of people would they be bringing in underneath them?
Right. So underneath them, in terms of like who the music supervisor themselves are paying, are their coordinators and their assistants. Okay. And I think that everybody is just, doing the same thing. If they're getting 1099, they're going to 1099 their assistant. What we're now hearing is that's not what we should be doing. Obviously, there's a lot of subcontracting that goes around, like in terms of hiring composers and musicians and things like that. But that goes, that comes from the studio's buck. So that's different. And like you said, musicians are exempt. But yes, most supervisors have people underneath them that they pay. So knowing that it is quite illegal to 1099 them is good to know.
And Kelsey, what about, I'm seeing a question here in the forum. I'm curious if any music supervisor has ever been hired as an employee on a show. I mean, does that happen, or is it just industry practice that everyone's always 1099?
I mean, from what and hopefully during the question section, people can, elaborate on that. From what I understand, it's just industry practice, but that there is some shows that will W-2 you, depending, I think, like networks, like if you work for a Disney-owned network, they will bring you on as a W-2, something like that. But a lot of them are just 1099s.
Yeah. That's what Aashish can speak more to this. I mean, we like industry-wide violations, and it sounds to me we've basically got an entire industry that is not in compliance with Dynamex, which now it's Labor Code 2775, which codifies Dynamex, and it says it's declaratory of existing law, which means it's retroactive. So I mean, that's a serious situation to be in, both in terms of hiring coordinators for exposure on your end as a supervisor, but also for the shows that are hiring. Basically everyone's exposed right now. I mean, that's a big problem for this whole industry.
I
Well,
would somebody just put in the chat that Viacom also. So I know that I think Disney does it sometimes and Viacom does it sometimes. Viacom owns a lot of networks. But yeah, it sounds like it's just a lot of people breaking the law.
Kelsey, Viacom and Disney give you W-2s or 1099s?
W-2s is what I've had personal experience with Disney, and then somebody in the chat said Viacom will also give you a W-2, but that is, I think they are the anomalies.
Okay. Well, you know, like Craig said, even if Dynamax does not apply, there is a test that you go back to. It's the Barillo test. It's a little more difficult of a test. But, you know, one of the problems that, and the reasons I think that California employers went a little nuts is because there was rampant misclassification going on and has been for a number of years. And with the gig economy coming on, where people say, look, I'll just start my own business. I'll start my own this or that. They forget that there is a whole set of labor and employment rules that have been initiated for a long, long period of time and that are very difficult to comply with if you don't know what you're doing. The gist I can tell you of practically every one of these rules that come out is to try to help the employee. It really is. They're not trying, the people that I talk to that talk to the people that are you know, writing these this legislation, they're actually trying to get it right. They're trying to give protection to the employees. But sometimes it's very difficult because you end up driving employers out of business, and that's the balance that California has always had to deal with. But I think given that we do have this test, we do have exemptions, the music supervisor issue is a very interesting one as far as I'm concerned, because you know, I am a class action lawyer, so that is how you do it. In those kinds of situations where you have a violation, where a classification, where a group has been classified as independent contractors on a wholesale basis, you should be allowed to challenge that classification on a wholesale basis as well. And that's why we have these class actions. We tell the judge that we could do it, you know, 1,000 times for each one of the individual employees, but we'd be here a long time, and you'd be here a long time. It'd be the Full Employment Act, really. So why don't we just have one trial, and we could have all 1,000 people. We'll have a couple of people represent the class, and we're talking about one issue anyway, whether these music supervisors, for example, are properly classified as independent contractors. So that would be the kind of thing that you could bring to bear. In terms of retroactive, under the law, under the Business Professions Code, you can get your wages back up to 4 years going back. The Labor Code says you can go back 3 years, assuming the Labor Code applies, of course. And if it does, then you go back 4 years. Now, it's an interesting situation, because what happens then if you are misclassified? What's the penalty? What's the harm? Well, what's the harm is tremendous. First of all, employers do it because the main reason they do it, it saves, I don't know, anywhere from, I've seen studies from 20 to all the way up to 50% in terms of your labor costs. You can start with your FICA and FUTA payroll taxes right there. That's 12% of which the employer has to bear, I don't know, about half of that. I forget what it is, but there's all kinds of employment taxes that you wouldn't have to pay. There's sick pay. There's, like I said, all kinds of wage issues in terms of recording and paying for time, making sure that you guys are paid for all your work. You know, I recently represented a group of music instructors at a very famous school here in downtown. It was a large group of people, and accomplished musicians like you wouldn't believe. I mean, the top 5% of all musicians I've ever seen at each one of these particular individual instruments. And they were music instructors, and they were being paid hourly. And so when they're being paid hourly, they don't get the benefit of any one of these exemptions. You know, they're professional teachers, this, that, and the other, but they're not. They're being paid, you know, $15 an hour, if that. So they had all kinds of claims for pre-shift time, post-shift time, when they were learning songs to get ready for teaching them to the students, when they were preparing their lessons like any other good teacher would, when they were taking questions from students afterwards and following up and creating special charts for some of them. So all of this kind of stuff that would normally be ancillary work somehow all gets put into the rubric of work performed on behalf of your employer, and it becomes compensable. So there are all types of not only back pay for you, but it's like when you rob a bank. You don't get to just say, "Ah, you caught me, so here's the money back." No, there are penalties involved. So here, the employer would face all kinds of penalties. And of course, there's lots of other statutes that you can use to really bring home some punishment on employers who do that. But that's, I think, where the world is going to end up, and a good place for me to stop. Why don't I turn it over to Tatiana? She had some things to talk about with the next section, unless there's something else, Craig, that you think I should cover here.
No, I think, Tatiana, why don't you take us into some of the sexual racial harassment issues? Maybe we can end up, if we have time, with the COVID and pandemic related stuff.
Well, today we're going to talk about, I understand based on the conversations I'm hearing that a lot of the people here in the panel are independent contractor as opposed to employees. But that being said, there is also a possibility that you are misclassified and you are really an employee as opposed to really an independent contractor. So I'm just going to give a brief explanation as to the laws that applies to employees, which is Title VII and FIHA. So under the Title VII Act of 1964 and the California Fair Employment and Housing Act, they both consider sexual harassment as a form of discrimination in the workplace. And what is considered to be sexual harassment? Any sexual conduct, comments, if you receive an inappropriate text messages like images of sexual images on your text, unwanted touching on behalf, it can be done by a supervisor, by a coworker, or by a third party. It can be a customer of your employer, a vendor that comes and engage in sexual conduct towards you. And those are protected under the Civil Rights Act under FIHA and Title VII. What can you do if you're the victim of sexual harassment? Usually the employer should have a policy as to what to do. You can file a complaint with the human resources, or they usually have like a 1-800 number established. You can, file a complaint to that 1-800 number. Whatever you do, make sure that you follow up and keep track, keep evidence. You write down the complaint, keep a copy for yourself. And even if you complain using a 1-800 number, you follow up via email or follow up in writing by fax, but always so that you can keep track of it. Because, oftentimes when clients contact our offices, the issue is that, there was sexual harassment, but the challenge is how we prove it, because, they didn't make any complaints. They don't have any witnesses that can corroborate the actual sexual harassment that they experience, and that becomes challenging. So that's what I think is very important, that you actually always report the sexual harassment. I know that it's challenging, or you're scared of being fired or terminated or the hours being reduced. So that being said, the law protects against retaliation. If the employer has an once you made a complaint, the employer has an affirmative duty to take action to stop or remedy the harassment. If they don't do that, then, and after you complain, they take retaliatory actions towards you, you have another claim for retaliation against them, in addition to the sexual harassment claim. Sexual harassment can be in the form of a quid pro quo or sexual hostile work environment, meaning that quid pro quo, meaning, the employer engaged in conduct, it means this for that, meaning that the employer said, well, I'm going to promote you, but if you engage if you go out with me, or I'm going to give you this job if we go out for drinks, And I don't know if if you see the movie like Bombshell, where it was a scene that the actual director of the Fox News asked one of the a reporter, she wanted to get a promotion, a specific job, and he was asking her to lift her skirts or shows, some of her, engaged in sexual conduct, and that could be like quid pro quo. It's severe enough that you can bring a claim for sexual harassment. And a hostile work environment will be like the harassment is so severe and pervasive that you cannot reasonably perform your job, because you can't engage you can't do your job because you're harassed constantly hearing, for instance, could be somebody making comments in the workplace about a coworker making a comment about his sexual engagement, his sexual activities, and it's in your presence, and it obviously makes you uncomfortable. You can't really concentrate on your job because he constantly making sexual comments about his sex life. The harassment doesn't necessarily have to be directed towards you, but if it's the harassment, like in this example, if it's so severe and pervasive that it affects your work, unreasonable, then you also consider to be the victim of a racial sexual harassment in the workplace, hostile. What can you do? Like, after that, after you file the complaint, if you feel that they don't take any actions to stop or remedy the harassment and the harassment continues, you can take further steps. You can consult an attorney about your rights or your options, or you can file a complaint with the Equal Employment Opportunity Commission, that's under federal law, or you can file a complaint with the Department of Fair Employment and Housing. Under Title VII with the EOC, you have 300 days from the last incident of harassment to file a complaint for sexual harassment. And under state law, initially you had only 1 year to go back and file a complaint, 1 year from the last incident of harassment to file a complaint. But under Gavin Newsom signed the bill AB 9, which allows you to go back 3 years, meaning from now you have 3 years from the last incident of harassment to file a complaint under state law for sexual harassment. Before, it is important to know, even if you go to an attorney, you still have to file first with the EOC or the Department of Fair Employment and Housing before you can file a complaint directly in court, because they have to give you something that is called the right to sue, meaning before you have the right to file a case directly in court, they are the one that issue you, okay, you can just go and file that complaint in court. Or alternatively, you decided, oh, well, I don't want to file in court. I want to just have the EOC investigate my claim, or I want to have the Department of Fair Employment and Housing investigate my complaint. They usually have, two things can happen. They actually can set your case for a mediation process, or they can investigate the case directly. And actually, if they made a determination that there is a cause finding, they can actually maybe proceed and litigate your case on your behalf, on behalf of the state, but represent you in a case against your employer.
Hey, Tatiana, in the chat, they're asking, what happens if you were misclassified as 1099? Do you have any rights if you were sexually harassed, and is it worth it? What can you do in that situation? Well,
if you were misclassified as a 1099 employee, then yes, all these laws will apply to you, like Title VII and also FIHA, the California Fair Employment Housing Act, because you are really an employee as opposed to an independent contractor, and therefore these laws and these protections applies to you, and you can, you have a claim for it. Obviously, if you for FIHA you have 3 years, so if we are within the 3 years, you can still file a claim for sexual harassment. Regarding the evidence, I wanted to also point out that it's important. I know that sometimes to preserve everything, like, if they send you text messages about sexual harassment, I know that usually the first instinct is to delete it, because, you don't want to, a conduct that behavior is unwelcome, you don't want it. So your first instinct is just to delete all that. But actually that is important evidence that we need. Even if you have text message, because I know a lot of the time clients call us and, oh yes, I was sexually harassed and he sent me text messages, but I don't have it because it was on an old phone, right? So usually now we can recover all those messages. We have someone from IT and look at that old phone, or maybe get those messages from the iCloud and get all that, because that's actually is important evidence that we can recover. Also, it's important to maybe keep a journal. I mean, all the details of the harassment, on this day, he made this comment, on this other day, this happened, that is important, when you want to establish your case, because when you present a complaint, the more detail obviously is, you cannot have such an imagination that you want to create all this, and somebody just once told me that detail is the stamp of the truth. So I think it's important that was great. So I think that's important to, to keep a detailed journal of, I understand it's a very sensitive experience that obviously, it's hard to kind of write, that when you are experiencing sexual harassment per se, and it's very difficult. But it's, once you want to bring your case, all those things can help establish that there was sexual harassment. And something to point out, if the harassment is conducted by a supervisor under Title VII, there's an argument that the supervisor or the employer will be strictly liable for the harassment if they have taken tangible action, meaning that if, in addition to the harassment, the supervisor reduce your hours because you didn't accept his advances, or the supervisor also fire you, there's an argument that then you have even the supervisor will be strictly liable for the conduct. Now, if the harassment is done by a coworker, we have to establish notice that the employer was on notice of the harassment. And that's what is important, that you complain and keep a copy of that complaint, or even when you submit it to Human Resources, take a photo of that complaint. Just keep track for your records so that you have evidence that the harassment occurred and evidence that you complain about it. And if the harassment continues, and you have evidence that you complain and the company failed to take action to stop or remedy the harassment per se. I understand also that some of the people working here can say, oh, well, I'm definitely an independent contractor. I have my own business. What are my options, or what recourse do I have? Under the Unruh Civil Rights Act, which is California Civil Code Section 51.9, it also protects or gives the recourse for people to bring claims of sexual harassment if the harassment occur in a business or professional setting outside of the regular employer-employee, meaning, and more recently, SB 224, which passed in 2018, actually add to that provision, you can bring claims for sexual harassment against producers and directors, which you couldn't do it before. So, you have to prove that there is a business or service relationship, that the defendant engaged in sexual advances, demands for sexual conduct, unwanted touching, and that you also have to prove that the severe was unwelcome, the sexual harassment was unwelcome, that you have suffered injury. The injury can also be emotional distress, or you have suffered some loss, or will suffer loss as a result of that sexual conduct that the defendant engaged. So, even if you are not an employee, and then, they say you have you go to this show and this director or this producer is engaging in sexual conduct towards you, and then you're saying, well, but I'm not an employee, what are my recourse? Then in that case, one of the actions that you can present is the Unruh Civil Rights Act, which is California Civil Code Section 51.9. And you can even, let's say you don't want to file it in court, you can file it with the Department with Fair Employment and Housing, and they will investigate that complaint under this act. So you have some recourse that you can bring for this case as well.
So Tatiana, if someone's a music supervisor on a show and the director or producer is hitting on them, making advances, commenting about their body or whatever, something like that. So you're saying even if they're not an employee of the show, they can still pursue a sexual harassment claim?
Yes, they will still be able to pursue a sexual harassment claim under the Unruh Civil Rights Act. And let's just say they don't find a counsel to represent, they can still file it with the Department of Fair Employment and Housing, and they will investigate that complaint.
Okay, and what kind of relief can they seek? Can they get?
Well, they can get attorney's fees, attorney's fees, damages, and then they can get treble damages for this under this Unruh Civil Rights Act.
For their emotional distress.
Yes, for the emotional distress, correct.
Okay. Aashish, have you had any experience with the Unruh Civil Rights Act for suits against directors, producers, or I know in the old days that law was used mostly for to sue doctors or therapists, or where there was a fiduciary relationship, realtors or whatever. And then after the Harvey Weinstein thing, they expanded it to be able to sue directors and producers. So have you? I haven't had a case like that yet. Have you had anything like that, Aashish?
No, I haven't. I've used the Unruh Act, but in relation to a class action where we ended up suing the state of California because there's qualified immunity for all kinds of things. And there was a case where I used the Unruh Act to sue because African American people, when they got transferred to the San Joaquin Valley, and would get something called valley fever, and they were 10 times more likely to get it than non-Black people. And there was a federal court order telling the California Department of Corrections not to transfer Black prisoners from LA to the San Joaquin Valley because they could get valley fever. My client committed a crime, was here in Los Angeles, and got transferred to the San Joaquin Valley and got valley fever. So we sued the state of California, but we couldn't sue because they have qualified immunity. We sued them under the Unruh Act, and we originally won, but it got reversed on appeal. So
were you, I know you were one of the lawyers on that big USC sexual assault case with that gross doctor, the $1 billion settlement. So are there, and Tatiana, you can address this also, are there remedies? Let's say somebody, God forbid, was sexually assaulted, or there was, I know, with the Harvey Weinstein, you see sometimes it can be even attempted rape and stuff. So outside of these laws for sexual harassment, what about those kind of claims?
Well, I was involved in the case against USC. There was a OBGYN doctor there. It's no secret, Dr. Tyndall, who's been indicted now or about to be indicted, involved in sexually abusing well over 700 different students there while he was examining them. In that kind of situation, you do have the panoply of all tort law. You're not limited to what, just employment law or FEHA or the labor code. So we did throw the kitchen sink, and you've got all kinds of, just regular assault, battery, negligence, those types of claims that you have. But I'll tell you, the biggest claims that we had were against USC itself. The doctor, what are you going to get out of him? Really, the biggest claims that we had were that this was reported and reported over and over again, and it was not taken care of. And the fact that they had covered it up, the fact that they had, not taken it seriously for so many years after so many complaints, that put them in a really bad posture. And so we did get a very good settlement for all the people that are involved. But there's a large, if the problem is sexual harassment, that is a very, very serious offense, and the law does provide a lot of different remedies for that. You're not confined to just what we're talking about here today. So that's a larger issue, and if something like that has happened, you should absolutely go contact an attorney about that.
Tatiana, what happens if people are afraid that they'll lose their contract or they'll lose their job if they come forward?
Well, that's why it's important to document when you complain, because, the law, obviously, the Congress, the legislator obviously implement this bill to encourage people that experience sexual harassment to come forward. So there are very strong retaliation laws that protect you in case that you've been retaliated after you commit a sexual harassment complaint. So, that's why we want to make sure that you prove it. And because there's a way, let's just say you complain about sexual harassment and they change the condition of your employment, meaning not necessarily that they have to fire you or terminate you, but meaning they reduce your hours. Instead of working 40 hours, now they're giving you 30 hours, which is kind of out of the random, so that's changing the terms of the condition of your employment. Or you were doing certain job and then they remove you to a different location, which make it harder and more difficult, or lifting, you have to lift objects, which is require more hard work as opposed to what you were hiring in the first place. Then if that's the scenario, that's changing the condition of employment, and that's considered to be retaliatory. And there are other claims that you can bring, and you can recover back pay for that reinstatement, for that, if you get retaliated or terminated because of making a sexual harassment complaint.
I mean, this is a real issue, retaliation, fear of being blacklisted, not getting other jobs. I mean, Aashish, you've probably had this experience too. For every courageous person who's come forward and brought a case, I've had two who said it's just not worth it. I'm just going to pocket it because, I may not get work again in this industry and I can't afford to do that. Tatiana's saying there's strong remedies. But what would you say to someone who's got a good sexual harassment case, who's genuinely worried about being blacklisted? I mean, we all know it's real. We know it happens. You can't deny that. So what would your advice be?
you have to make your own decision on that. There was a case I had, it wasn't a sexual harassment case, it was a failure to pay. It was a very famous artist that everybody would know. I won't repeat her name. And she decided she wanted to play a New Year's Eve gig, and she was going to give every musician there, I think it was like $3,000 for the night. You know, and they had to do the rehearsals and all that, but that's a pretty good payday, and New Year's Eve is a pretty good payday for that. So she had rehearsed a band and got them all together. And then 2 weeks before, she didn't show up to any of the rehearsals. And 2 weeks before, she, of course, you know, it just sounded horrible and terrible, and it was all terrible. She said, I'm not doing it. I'm backing out of the thing. And so these people came to me and said, look, what can we do? You know, we're musicians. We really need this. It was, you know, a gig we're counting on. You know, $3,000 is a lot of money. And so I ended up writing a letter. It was, to them, it was worth it, because they said, hey, we may not work with this person again. This person's on the downswing. This was really bad. And they took a chance. But I think that what Craig is saying does have some merit to it. It is still a small club in the entertainment world. We know that. It's a very small club in terms of who makes the decisions to hire you for these jobs. And you've got to stay on their good side. So I'm not saying anyone should put up with sexual harassment. That's a bridge too far. But if it's something short of that, if it's something else, you have to make your own decision, because there are ramifications. And the only thing I can say is that in the wage and hour context, whenever I've had long-term employees and they say, look, I want to sue, we don't think we were misclassified. Let's say we're all misclassified as independent contractors and we're really employees, and therefore we deserve all this. I tell them, look, generally speaking, you know, these wage and hour cases, they're not a question of a personal hatred to the employer. They're just a question of business. I did the work. If the law is I should get paid for it, that's all we're asking for. We're not asking for a windfall. We're not asking for a lottery win or to be retired next week. We're just asking for the wages that, by the way, we've already done the work for. So those kinds of cases, when you do file a lawsuit, and I put someone on there, I usually try to put one or two. I usually try to put two or three actually in the class representative spot. Is that when and they say, boy, we've got a target on our back, Aashish. Wait till the boss sees this, we're going to be crucified. I say, you watch. What's going to happen is, as soon as you file that complaint and they see the three people on there, those three people get treated better than anybody ever has gotten treated in the history of this corporation.
If they've got good lawyers,
because they know they've got lawyers, they can just amend the complaint and put a wrongful termination cause of action right there. You want me to add another cause of action? Let's keep going. What else you got, you know? And so they know you've got a lawyer. They know you've got a serious claim. And if you've got a reasonable argument, they're going to treat you very well. And they're going to, you know, I view it as you borrowed $100 from your friend. Well, 3 weeks later, you say, look, you're still my friend, but I need my $100. Okay, I need to live. So it's just a business decision.
I hear what you're saying. I think that's true in many instances. Sometimes, unfortunately, you get the real bad apples. I have had a couple of clients who've been fired after bringing cases. Those are the ones I feel the most passionate about, go to bat for them. And just in general, what I would say is there's strength in numbers. So a lot of people coming forward, it's harder for people to retaliate and blackball. And another useful thing is some of the agencies like the EEOC will do commissioner charges. You can file anonymously if you have several people, and sometimes get one of the government agencies involved. So those are some of the things I'm advised to people who are really, really concerned. I used to tell people, look, you're not going to get fired, just like you're saying. They're going to hire another lawyer like me. When I first started my career 22 years ago, I worked 3 years representing companies. The first thing we would tell the company when a complaint came in is treat this person with kid gloves, because we can deal with it. We can settle it. But if you fire them, now we're talking punitive damages. So avoid that. So I think you're right. That's true for 90%, but there's those 10% of bad apples who are like, we're just going to go after this person now. We're going to go after them hard. And we're going to notify everybody, don't hire this person, or just let them know, hey, by the way, this person's suing us. You might want to be careful. And it's really hard to stop that. And so in the old days, I would kind of overcommit. We'll protect you. It won't happen or whatever. But I've seen a couple instances. I mean, it's only been 2 or 3 times in my career, but I've had a couple of plaintiffs who were fired after we brought the case. And, that was just a disaster. So, it's a real thing. Huh?
That was filing anonymously is a good tip because I've tried to file anonymous. If you're in a situation where you've got such a heated situation where you know that if your name is even on this thing, it could cause all kinds of problems. There are ways to file anonymously. You can, Jane Doe, kind of whatever you want to do against whoever. And so there are ways to do that. In my experience, though, almost all of those eventually get disclosed. The defense will file a motion to reveal the name, and it's almost impossible to keep it anonymous. But it is interesting because what it'll do is it'll show up as, Jane Doe versus, big hotshot defendant right here. And that's the way it'll show up on the docket sheets and everywhere else. And if you try to Google it later, I find that that's all you'll get is the Jane Doe versus whomever. For example, the USC cases are all Jane Does versus, USC. There's not a person, you couldn't find out any one person who was involved in this case, even though it resulted in, an almost $1 billion settlement. Yeah. So there are ways to keep it quiet if the stakes are high enough. But even if they're not, that's a good trick to put an anonymous name up there. And then if you get forced to reveal it, you'll create less friction for people searching later. Using
on kind of a tangent of what we're talking about here. Some of my clients are asking me now, hey, in the future, let's say I file this EOC charge or I file this lawsuit. Is this something that future employers are going to be able to know about if they do a background check? That comes up pretty frequently. So let me just address that topic very quickly. So EEOC or DFEH charges, Tatiana was talking about those are not really publicly accessible. You can get it through a Freedom of Information Act request, but you have to know the person's name ahead of time. Background check companies can't get those. So you're kind of safe while it's at the agency. Once you're in court, that's all public record. The federal court, the PACER system can be searched very easily. Each state court, believe it or not, they're not all interconnected, but each state court has a website that's, for a fee, you can search pretty easily. But what I have found, because I've looked into this for different clients, the basic background checks that most companies conduct, and of course there's Google, right? Sometimes you just Google a person's name and the case might pop up. So that's worth checking too. But the basic background checks that are conducted, the normal ones, do not actually reveal prior employment lawsuits that have been filed. For an extra fee, an extra couple of $100, a company can hire somebody to get that. But most of the companies who conduct just the basic background checks, that doesn't actually come up. So that's information that I only learned in the past, year or so when I actually looked into it. And I don't know how many companies, spend $300-400 on every applicant to do a full workup of all of the public record filings and prior lawsuits and all that. Maybe some do. I think most probably don't, but some probably do. So what's your, Tatiana, Aashish, what are your thoughts on that?
I just wanted to mention that, in the event that, for instance, we file a case and we reach an agreement on, with the defendant in the case, we can always include a provision in the settlement agreement to prevent retaliatory actions taken towards the plaintiff or the victim in this case. And we usually include a clause there, to prevent that, or that they only provide neutral reference, meaning like if they want to find new employment, when they contact their former employer, they can only say the days of employment when she works there, and that's it. They cannot say anything disparaging or negative about the plaintiff for bringing a case, which we found that to be helpful, in those cases concerning retaliatory actions. And also I wanted to point out that they can even before they can include a no rehire provision when they have settlement agreements in sexual harassment. Or they pass a law in California that is prohibited. So they cannot even include a provision saying, oh, we're not going to rehire you back here, but in case you in the future, you might want to apply there, or if it's a big company, you want to apply there, you can do so as well.
Yeah. Also, one thing I wanted to mention, everything Tatiana said about sexual harassment is true about all of the protected categories. So that would include race, religion, age, sexual orientation, national origin, disability, gender identity. All of those kind of things are protected. You can't be harassed on any of those categories. For some of those, you don't need an employment relationship to bring a claim. For example, for race and national origin, there are laws like the Civil Rights Act of 1866, also known as Section 1981, that any kind of contractual relationship gives rights that protect you from discrimination on race or national origin, including harassment. And unfortunately, due to the political environment over the last few years and other factors, at least in my firm, we've seen a significant uptick in racial harassment in the workplace in certain industries. I've noticed it in construction. I don't know if that's true in entertainment, but there have been, unfortunately, a lot of strong racial harassment cases coming into my office, and we're handling a lot of those. So I don't know if, Tatiana, Aashish, have you guys seen any of that or heard about that?
Yes, I think in the, well, like you're saying, in the last 2 years, there has been an increase in racial discrimination cases, particular certain industry in construction, with the former president that we have, that kind of increment, an increment in racial discrimination cases. And, like Grace said, we have encountered those that, and also in gender discrimination, sexual orientation discrimination as well.
Yeah. So Kelsey, we had another part of the panel that we can go to on COVID and pandemic stuff, but maybe I'm kind of personally tired of talking about the pandemic. Maybe we could just open it up to questions now instead.
I think that's a good idea considering the time. I have some questions here, but if anybody in the audience wants to ask the question themselves with their own voice, you're welcome to raise your hand or also just put it in the chat box and I'll read it out for you guys. So I'm gonna give you a couple minutes to do that. Nobody's wanting to do it physically.
Bueller.
Okay, well, I'll start with reading some of the anonymous submissions.
Okay.
Here is one. If I'm a freelance / sole proprietor, what do I need to do to legally have an intern who is not receiving college credit?
Jeez.
You've got to pay them. You got to put them on the payroll and do all of that.
Yeah, there used to be a rule that interns were exempt from the minimum wage laws and from the employment laws. And so many agencies, talent agencies, et cetera, got sued for that. The law now is basically, unless they're getting college credit, you have to treat them as an employee just like anybody else. So you can't really do the whole, this will be great experience for you and you're going to do it for free thing anymore. That doesn't work.
Right, so they have to pay the minimum wage, basically.
You can't work for Cray-Merica and go to NYU and get a great intern who's going to schedule your lunches with Jerry Seinfeld and, Costanza.
Okay. Okay, I will move on to the next question. If I'm being paid as an independent contractor, what can someone require of me? I.e., being at a particular location, specific hours, and does it have to equate to a minimum wage? I think people are asking, like, are they allowed to tell me what hours I work and where I physically have to be if I'm 1099?
The problem is they can tell you some of that. They can't tell you all of that. If you need, think of it this way. If you're going to call Roto-Rooter and you need your plumbing fixed, you need it fixed now. You're telling them when you need it fixed. That doesn't mean that you're their employer all of a sudden. But the more of this you do, the more of the ABC test, the A of that test, you are destroying. So remember, the employee has to be free of the control of the employer, and it can't just be ephemeral. It can't be just in writing, in theory. The employee, the independent contractor rather, has to actually be there to do their job themselves, and that's where the more you get involved and tell them, well, I need you to show up at 9:30, use this lens, don't use that lens. I need this shot over here. Then you need to go over there. And I need you to pack up your stuff. And then the more you do that, you're going to destroy that first prong. And remember, you need all three prongs. If you don't have all three prongs, you're an employee. So
if they're saying, like, what will happen with a lot of music supervisors, like, we expect you to work from 9:30 until 6:30 at least. Yeah. That's not allowed as a 1099?
No.
No, that's the classic example of control over hours of work that is indicative of an employment relationship. So I think what you can do, you can tell them, look, I'm happy to do that, but you should just know that by asking me to do that, you're really treating me as an employee and not a contractor.
Right.
And so the answer, practically speaking, of course, if you have a independent contract relationship with someone, they can insist on all kinds of things or else just tell you it's not working out. But the thing is, like Aashish was saying, the more they do that, the more they lose the protection of the contractor status, which basically means they got to pay you minimum wage and overtime, time and a half. And California has daily overtime, 1.5 times your rate over 8 hours. They got to reimburse you for all of your business related expenses, whether that's mileage or whether that's, you're paying your team or paying, for your camera that you rented for that day or whatever the host of things are. And, everything that's in the labor code, they got to issue you wage statements twice a month. And there's a $4,000 penalty per year, if they don't do that. So, they can insist on all kinds of things, but that just means if they ever get sued later on, they're going to lose. And on top of it, there's a $5,000 to $25,000 penalty for each misclassification for each employee. And so that's just a big problem for them. That it's in the discretion of the court where on that, where from the 5 to the 25 it's awarded. But yeah, and they can tell you to do all this stuff, but they're setting themselves up potentially to be sued later on and to lose, right, Aashish?
Right.
That's per employee, by the way.
Yeah, per
Correct.
employee.
Per employee.
This is all very interesting to us, as I'm sure, because we are all now realizing we are being misclassified. Okay, well, let me move on to another question. Somebody said, and I don't know what this is, can you explain the administrative exemption in California?
Yeah. You want to do it, Aashish, or should I, or Tatiana?
Yeah, here's the best way. I try to do any administrative or management type of exemption. If you are creating policy, you're exempt. If you're following policy, you're not exempt.
Let's back up a second. With the question Kelsey is asking, exempt, not exempt relates to overtime. There's two issues of exemption. Are you W-2 or are you exempt in 1099? This question is not asking about that. This question is asking, you are a W-2. Do you get overtime? Most people do, unless you're exempt from the overtime requirement. Manager.
This person is specifically saying, do executive assistants fall under the administrative exemption?
Right.
Very likely not. The rule is you have to spend more than 50% of your time performing duties with independent and discretion on matters of consequence.
Okay. Yeah, I don't think an executive assistant.
Matters of consequence. Yeah, you can't be opening somebody's mail all night long, and that's not. So, in order to truly be an independent, an administrative exempt employee, you've got to pass a salary test and the duties test, meaning that you have to have a salary that fits within the particular parameters, and then the duties test, which is the part where everybody falls apart because you have to spend more than half your time doing really things that are administrative type things, running the business, hiring,
delegating, okay.
Having a budget, things of that nature.
Okay, cool. Here's another one that I think people are getting tripped up on. They want to know, is it okay to be, because we're supervisors and we're being misclassified 1099, a lot of people work on multiple shows or multiple films at once. So they want to know, is it fine to just have unlimited amounts of W-2s going at the same time? Like you could be working for Disney, Netflix, Viacom, Universal all at the same time, and you would have a W-2 for each of them. And is that legal?
That is legal. You can have more than one employer at a time. Think of it this way. You could have 3 part-time jobs and they would all issue you W-2s. There's nothing wrong with that. I think what the question might be driving at is, wouldn't that perhaps be an indication that you are a true independent contractor and not an employee? Sometimes Uber and Lyft and all the gig companies changed the law in the last election. There was this, what do they call it? The ballot initiative to elect Prop 22. Super annoying. That's only prospective, not retroactive. But basically what they were saying is, look, we have drivers that drive for multiple different companies. They really are, independent contractors or whatever. But the courts were saying, no, they're employees. They're just employees of multiple companies. So they had to come in and actually change the law to create a new category, which is kind of like a dependent contractor category where they sort of get the equivalent of minimum wage. They sort of get some health benefits, but the companies can treat them as 1099. And in the old days, if somebody worked for multiple different entities, that is a pretty powerful factor that they're a contractor and not a W-2. But with this new ABC test, that's not the key or even the dispositive or even the central factor, because you can have more than one employer. And if each of them is controlling your work schedule, and exercising control, and you're in the same business as them, you just have multiple employers. That's all. And by the way, you can have You can also have what are called joint employers or co-employers. Like a lot of times in entertainment, there'll be an agency that sends somebody, like Pro Unlimited sends somebody to NBC Universal. In that situation, the way the labor code and the courts will view it is you have two employers at the same time. You have a joint employer. You know, as we would say in Texas, you got mama on the drums and papa on the fiddle.
Okay. Makes sense. Another question I got from a couple people, they wanted just a little bit more clarification on, I know this is, I think it's just California, that employers aren't allowed to ask for your salary history. I think that's news to some people. Is that what it is?
Yeah, there's
California.
now 14 states that have banned that, not just California. You
Okay.
kind of have, if you just Google, you know, asking about salary history and the particular state you're interested in. Somebody had asked about New York. New York's one of the states that's banned that now. Oregon has banned it. A number of states have banned it, including California. So it's
if an employer does ask that, like, how do you respond? Do you say, like, I'm not going to disclose that per the law?
Yeah.
Well, you should demur to it. I mean, these are, you know, political questions. You gotta be a little savvy with it. You know, you gotta say, well, I'll take a look at it, but are you sure you're allowed to ask that? Or I thought that maybe this wasn't appropriate, or I'll take a look at it and get back to you, and then kind of let them know subtly that they're not allowed. Most people don't know they're not allowed to do that.
Right.
People do not know that there is this law out there.
Yeah, I mean, I think we're all pretty surprised that that law exists.
That's a Governor Brown one. I mean, that's like within the last 2 or 3 years. I think a Newsom one, 2018 or 2019 in California. It's brand new in Oregon. It's 2020 in New York. And, you know, all the social science research basically showed that the main reason why there's the pay disparity, a gender issue between men and women, is because that first job, going all the way back, women took a lower number than men, and it's just been entrenched over and over again. So the natural thing is, so what were you earning at Facebook? Well, I was getting paid 75. All right, we'll bring you in at 75, but that may be below their pay scale. They don't care. They're just trying to save money. But what all the states now have recognized, that has what's called a disparate impact on women as a gender. And so there's actually some amazing cases now. My firm is one of 4 firms suing Nike in a class action on behalf of 5,000 women at their corporate headquarters because Nike asked about prior salary history. And our expert in that case has shown women are earning less than men in every job category at Nike by $2,000 to $3,000 per year. The combination of asking about prior salary history with that statistical disparity is what creates a good class action case. And there's lots of cases pending like that now. It's not it's illegal to ask about it, but there's no real consequence or damage to pursuing the case unless you can also show that it's resulting in a pay disparity against women. You know, so in other words, if they're asking about it, but the data doesn't show gender discrimination, it's like an illegal practice without a damage, you know. But if they're actually paying women less than men and they're asking about it, you know, Aashish and I and Tatiana would love to bring that case together, particularly against a large entertainment company.
And by the way, shockingly, when you run these statistics, it almost never works out that there's not a pay disparity.
I know.
It almost never works out.
Yeah.
There is always a pay. If you run the numbers, just run the numbers. I mean, how do you think the federal government gets these statistics where they say, well, you know, it's a great day for women because now they earn 77 cents for every dollar that a man earns? You know, where do they come up with that? Well, there are numbers out there, and statistics don't lie. So it'd be shocking that to me that there wouldn't be one. So if you have a situation where an employer is asking, like he's got a good one with this Nike case, where they did ask for it, I'm sure that once their expert finishes with the evaluation, they're going to find that there's going to be a disparity. I'd be shocked.
So our expert, who's a leader in the field, the expert report alone cost $700,000 because she had to analyze the pay records of 5,000 women, 5,000 male comparators, and to take out every factor other than gender, doing a regression analysis. Very, very time consuming, very expensive. But once she finished scrubbing all the data, and it shows, you know, even taking out all of the factors other than gender, there's a clear discriminatory impact here. You know, maybe you guys will be reading about it in the papers later this summer or next year, but, you know, Nike's in trouble.
They're not alone. Did you?
What's that?
Did you say $700,000 for the expert report?
Yeah. Okay, we'll talk later, Aashish. But yes, there's 4 law firms on it, so we split it 4 ways. I know you like to do all
it's not expensive, is Craig's point, and I fully sympathize with that.
Yeah. Okay. Anyway, what else, Kelsey?
Tangentially going off of that, we wanted a little bit of clarification on asking for pay scale. So if you are getting a job offer from somebody for a W-2, you're allowed to say, thank you for this offer. Can I get a pay scale report?
Yep. And
you have to provide it?
Yeah, they have to. Look, I'm going to show you. Maybe we can do a screen share. But this is something I don't think anybody knows about, right? Or very few people know about. But it's an amazing law. It's really amazing that they are required by law 432.3. Here, I'm going to bring it up on my screen. How do I share this? I just click the share screen.
Yeah, and then choose the one that you want to share. There.
So here, so this is the labor code 432. An employer, so I'm looking at C here. An employer upon request shall provide the pay scale for a position to an applicant for employment for purposes of, what is the rest of it? For purposes of this section, pay scale means salary or hourly wage range. For purposes of this section, reasonable request means a request made after an applicant has completed an initial interview with the employer. So that's California law. I mean, that's black and white. Huh?
And this definitely applies to W-2s. And you said for people who are 1099, maybe?
Well, if they're misclassified and they really are employees, it applies to everybody.
Right.
They're going to say, no, this doesn't apply to you because you're a 1099. And the press back is, am I really a 1099? But I think the broader point is just like, this is some way to kind of get the information you need. You need a little bit of a leverage point, because, the companies don't just want to volunteer information. They like operating at an informational deficit where they have all the information and you don't have any. This is just a nice way to say, look, my understanding is this is a right under California law. I have a right to the pay scale. I'd like to know what's the highest, in terms of other people who've done this job, what's the highest you've paid and what's the lowest? And I mean, I just think it's an unbelievable weapon that most applicants don't know about. You only get that if you have an interview. So you can't do it off of just sending a resume. But once you have the interview, and then of course you should insist on the highest amount of the pay scale. Okay, I think you're on mute, Kelsey.
Sorry, I'm reading through the questions. Yeah, Levi said, Katie wanted to know, can you share that link to the pay scale and salary history law? If you could put that in the chat, that would be amazing.
Oh,
and
sure. Yeah.
And then also, so if you are 1099, you first have to prove that you're misclassified before you can ask for pay scale, is what you general summary.
The entire labor code applies to employees. Independent contractors don't get the benefit of the labor code.
Right. Okay. Okay. A couple questions I have. What is the time limit on filing a complaint or suit?
That's a good question.
Tatiana, let's talk about the sexual harassment. That's got a shorter time.
Okay.
I think, right?
To file a complaint for sexual harassment, if you file a complaint for sexual harassment under Title VII, you have 300 days for the last incident of harassment that you need to file with the EOC. Now you're going to file under California state law. You have 3 years from the last incident of harassment to file that complaint with the Department of Fair Employment and Housing before you can file in court, because they are the one that grant you the right to sue. Now, if we are talking about potentially wage and hour claims, like as she's mentioned, you can either go back certain claims 3 years, depending on what is the claim, like wage, for, failure to pay overtime, unpaid wages, you can go back 3 years. And you can go under the Unfair Practice Business Act, you can extend that to 4 years. Obviously, that is considering you haven't signed an arbitration agreement, because a lot of employees sign something called an arbitration agreement, meaning that all the disputes has to be resolved through arbitration as opposed to in court. If that's the case, then we will have to go through an arbitration process, which is different than state court. And also you have a potential claim for, they didn't provide you with a pay stub, or for those, you can go back 1 year for the pay stub claims.
Got it. So on the safe side, 3 years.
Yeah. Somebody just asked about sexual assault. There's an exception California passed a law for any case involving rape or sexual abuse or sexual assault. There is no statute of limitations anymore, right, Ashish? Isn't that
Right, on assault, but on harassment, it was 300 days, right?
300 days under federal law and 3 years under state law.
That's
Okay.
right. Yeah. As Ashish said earlier, for wage claims, it's 4 years. For penalty claims, it's actually 1 year. So the penalty for misclassification, 5K to 25K, you only have 1 year to bring that one in court. And any claim for penalties, wage statement penalties, misclassification penalties is 1 year. Claims for reimbursements or unpaid wages or missed meal and rest breaks, which we didn't really talk about today, but that administrative assistant, for example, if she's not getting her meal and rest breaks on time, a 30-minute duty-free lunch by the 5th hour, 10-minute breaks every 4 hours or major fraction thereof, they have to pay 1 hour of pay premium every day that's not provided, one for the meal, one for the rest. And you can go back 4 years on that. There's a lot of cases involving meal and rest breaks over the last few years in California.
Yeah, we didn't mention also about reimbursement of business expenses. People that are working from home nowadays, they have to use their home internet expenses. They have to use their computers, their phone. They should be entitled to reimbursement for it.
Right.
Yeah.
Okay, Katie has a question, so I'm gonna let her take the floor.
Thanks so much, and thanks everyone for your contributions. This has been really informative. I was wondering if we could circle back a bit to the questions about internships. I am trying to put together an internship program, and so I have some other specific questions, but I know our whole industry, everybody likes having interns. I was wondering if you could talk a little bit about sort of the different, is there any difference between California law versus federal law? And are there any kind of, structures that you've seen or heard of where, somebody could make use of like grant money to pay an intern for a placement with a job?
Like a scholarship.
Yeah. So,
okay, interns are a very complicated scenario. Both federal and California law essentially operate on the premise that you are doing the intern a favor rather than the intern doing you a favor. And it matters on which way it goes. In other words, if the intern is there primarily for the benefit of the employer, then they're not going to be considered a true intern, and they're going to be considered an employee. An intern is really supposed to be a learning exercise primarily to benefit the intern. But if you're going to have that intern do a job that an hourly could otherwise do, or that an hourly is doing, but they just happen to be an extra person to help out when the hourly assistant can't do the job, you'll get the intern to come in there and do the job. Those are the kinds of things that will blow apart your internship programs. The programs now, you have to go through a college or a trade school or a junior college, and they will have a list of items. I think there is still a valuable, this internship program is a valuable program, but it just got so abused. It got so abused. People treat it as just a pool of just free labor. And they're not supposed to be there for free labor. They're supposed to be there for you to help them, for you to teach them something about the entertainment industry, for example, or or the legal industry or the accounting industry. You have to be in a position to impart knowledge on them. If you Google it, they'll have the tests there that you can have, the multi-pronged tests that you can, if you're actually trying to put something together, you can try very hard to make sure that you are, this is a curriculum course. This fits into a program that they could potentially get credit for, that there is an outline of activities, that there is a benefit laid out specifically in writing that tells them why this is good for them and what they're learning out of it. So if you can meet all those categories and you really are providing a service, if you're doing it right, the intern should be very difficult for you to handle if you're doing it right. Okay, if you're doing it wrong, they're a benefit and they're getting you coffee at Starbucks and shining your shoes and taking your shirts to get dry cleaned. But if you're doing it right, it's a very, very difficult thing, because you're in essence teaching. You're agreeing to teach someone what you're doing and letting them work under your thumb. So those are my thoughts on it.
So unless they're getting college credit, you have to pay them full time to teach them that and go out of your way to teach them that at a full-time hour, at a full-time wage.
Well, it's not just the college credit. I know that used to be a line of demarcation. You're going to have to go back and check it again. And the federal is different from the state, but it may not even necessarily be that they have to get the college credit. But I know that's one of the main categories. The problem becomes is that if they don't qualify as an intern, then what are they? And what they are by default in California is an employee, a W-2 employee at that. And then you could be on the receiving end of all the stuff that Craig and I and Tatiana are talking about. You don't want to do that. So I would say be very, very careful with internship programs. They almost generally don't work. I haven't seen too many that actually do what they're supposed to be doing.
Yeah, I agree. Unpaid internships are almost always illegal in California. If you get the school credit, that is an exception. And I've personally had an intern who got credited at Pepperdine Law School one of the summers, and then later on I actually hired him as an associate. There is a difference in the law. We can talk offline maybe if you want to give me a ring, but there is maybe a way to do it if you classify them as a trainee instead of an intern. And so that's kind of a quirky thing. Maybe Katie, if you give me a call during the week, I can point you in the right direction where there might be some way to try to do it. But in general, Aashish is right. I know no good deed goes unpunished. Help them. They're totally useless. They don't know how to do anything. It's a total one-way relationship. And you're like, and I got to pay them $12 an hour? You know? The answer is yes.
Okay, great. Thank you so much. I really appreciate that.
Okay.
Craig, I know there was another question in here that I didn't quite understand, but I think you read it about the employee of an agency that's owned by a larger employer.
Yeah. Okay. So this is a great question that was posted in the chat. So the question is asking, you know, at big entertainment companies and a lot of companies, if you're an employee, you're entitled to all kinds of great benefits. That could be health benefits. It could be pension benefits. In the entertainment industry, they actually have these industry-wide plans, the motion picture industry pension and health plan. So even if you go from job to job, you're still part of that. So, and they're great benefits. So the questioner is asking, what if I'm working through an agency, but it's like a perma-temp situation? I'm working on site for, you know, like my prior example, Pro Unlimited sent me to NBC Universal, and I've been there through the agency now for 8 years. But I'm not getting all the pension benefits, the health benefits, all that other stuff. So am I eligible for that or whatever? So let me just say that involves an area of law called ERISA. ERISA, not really my expertise. ERISA is the Employee Retirement Income Security Act, and there's different lawyers that are specialists in that. Those are the laws that govern pension and healthcare benefit plans. In general, it's just like this issue of employee independent contractor. Anyone who's an employee is typically entitled to benefits under a health or pension plan that says employees who work more than 35 hours get the following benefits. So like, for example, there's a case, you can Google it, Visano versus Microsoft. It went on for 15 years. All the perma-temps at Microsoft sued for health and pension and other benefits, and they won like $90 million after like a 20-year lawsuit. Aashish will tell you, quoted all the time, Ninth Circuit opinion. So that was an ERISA case where they were basically saying we should have been classified as W-2s. We should have been eligible for all these benefits at Microsoft. We never were. Sometimes people can win those cases, right? So if you're actually an employee of the agency and not a joint employer of the company, or if the health or pension plan of the company says our plan only covers W-2 employees and does not cover agency employees or joint employer situations or whatever, you may not have a case if the plan terms define you out. But if they leave it open-ended, like all employees of NBC Universal are eligible for the following benefits, you might have an argument that you're an employee, and that would be a massive, potentially ERISA case for all of the permit temps. Not really the kind of thing I handle. I don't know if Tatiana or Aashish have expertise in that, but there are really, really big Judge Dolly G, who is a federal judge here in LA, an excellent judge. She was one of the lead counsels on the $70 million age discrimination cases for TV writers that I was tangentially involved in a few years ago. And then she was promoted by President Obama to be a federal judge. Her old firm on Wilshire does these kind of ERISA cases. And there are firms that do that. So, you know, the companies might be thinking like, we've saved a ton of money classifying all these people as temps, but it could be, you know, that the temps may have actual claims to those benefits. One of the things you could do is request the summary plan description. They're called the SPDs, or have a W-2 friend of his request the summary plan description. That's kind of like a 10-page or 5-page summary of who's eligible for the health or pension benefit plan. And the HR has to give that at least to any employee, W-2 employee. So that would be the starting point to figure out if they're sort of defined out. I hate permanent temp relationships. I think it's really uncool to people who have to work in those environments. And they always tantalize you by saying like, if you just do this or that, maybe we'll bring you on full time. It's a really abusive practice that I see quite a bit. Aashish or Tatiana, do you have any comments on that?
Every time I hear the word ERISA, I know the employee loses.
Okay. Well, and they didn't lose in the Microsoft case, if you Google that.
With certain exceptions. I stay away from those things.
Okay.
Yikes. The person clarified though, they're like less about health insurance and more about vacation days, which this person doesn't get any of while the people at the main company does, which sounds insane to me.
Yeah, so that goes back to this misclassification issue.
Okay.
Who's really their employer? Is the agency their employer, or are they really working for the company? And it sounds like the agency offers no paid vacation, but the company does offer generous paid vacation. So, you know, if they're really a joint employee of both, you know, maybe they would have a claim for those unpaid vacation days. Might be a bit of an uphill battle, but the truth is, if they're working on site at, let's say, NBC Universal or Viacom or Fox or Disney or whatever, their supervisors are employed by those entities. They've got the badge for the parking lot for that entity. You know, their email says, you know, NBC Universal, so-and-so at NBC Universal. Why aren't they getting the paid vacation? I don't know. Those can be good pick cases, decent cases, right? Right, Aashish?
I like it. That's a good case.
Okay, so whoever that is, contact Aashish. I want either to be involved or 20% referral fee. Okay, thanks, guys.
Done and done.
Okay, I've got 2 more questions because we are running out the clock. One question that we got in the anonymous submission was, my employer forced me to go into work during the pandemic. Was that illegal?
These are really difficult questions because, what you mean, the employer forced them to go in when there were, you know, orders to not go in? That would be illegal.
During the quarantine.
Oh, well, that would clearly be illegal. The problem that you really see in these COVID type of situations is a situation where someone does not have COVID, but has a fear of getting COVID,
right,
and does not want to go in for a fear of getting COVID, even though the employer arguably has taken all the steps that it could possibly take. And the employee says, well, I know you did, but I don't want to come in because I just don't feel safe enough. Those are the hard questions that I see now popping up in the employer world. If it's a clear violation of something that was put out, then that you could sue under that statute, assuming I don't even think it has any remedies under it. But the problem we're going to see now is how comfortable does someone have to be? How many protections do they need in order to return to work? Do we have to insist on everyone being vaccinated, or is that going to create a problem? And so there's going to be a ton of issues here. I'm not sure if the rules that we have in place now are really equipped to handle that. And the liability going towards employers for, let's say someone goes and catches COVID-19 at work. Let's further assume that this person isn't someone who just recovers, but dies. If you catch COVID at work, it's a simple solution in California. The answer is it's workman's comp, okay? And there's a rubric for that and you're done. The harder case becomes, let's say someone dies from this. Then they have a wrongful death case against arguably the employer, and then what do you do then? Those are some of the things that I know that on the federal level they're talking about. They're trying to create some kind of immunity. That's one of the stumbling blocks of getting the COVID relief, or we're going to have some liability limitation for employers. But honestly, I haven't seen too many of these kinds of cases really being filed. I think with the court system, the way it is so backed up that if we start filing these kinds of cases where there's really not a clear answer, judges would get upset. Go ahead.
At the risk of giving Tatiana and Aashish, my colleagues and competitors, some business ideas to compete with me. It is against OSHA and against CDC and Cal OSHA rules for companies to require people to work in an unsafe working environment, which would include pandemic-related unsafe conditions, like forcing someone to come in during quarantine or work without masks, during the time when the pandemic was really active. And it's a PAGA violation, Aashish, in California. So there's a law that allows you to bring penalty claims for any violation of the labor code, including these OSHA-related claims, $100 per employee per pay period, going back 1 year for anyone who was forced to work there. I'm interested in those cases, also particularly interested in companies requiring people to do temperature checks off the clock for hourly employees before they go into the studios. Also interested in people requiring COVID questions and health questions without paying for that time. Also interested in reimbursement claims for cell phones, for companies requiring people to download apps to answer all the questions about, whether they've been vaccinated and all that. So all that stuff I'm actually kind of interested in, but I don't know how relevant it is to our audience today. But I like those cases, Aashish, because people didn't think a lot, just like Tatiana said, they didn't think to reimburse people for their home internet expenses, even though they certainly should. If you're working from home and it's for W-2 employees, they have to. And I've actually got a bunch of cases now against Oracle, KPMG, Accenture, a lot of big companies, including NBC Universal, for sending people home and not reimbursing for home internet, home office expenses. I love those kind of cases under PAGA. And so, let's do some more. And if anybody in the audience is interested in those or knows somebody who is, I'm sure Kelsey will be happy to provide my contact information later. And yes, and
well, that actually leads me to our last question. How much does it cost to retain any of your services or to move forward with this, or consultations or any of that stuff? People just don't know what this costs. Okay, I got nothing, it looks like.
We don't win unless you win, right?
Yes.
we work as a percentage of whatever we're able to get. If we don't get anything, we don't charge, and all consultations are free. Please don't take advantage, but up to an hour or so, I'm happy to speak with anybody to answer any employment questions. And Kelsey can send around our contact info. All of us are generally open and available to answer questions. It's been such a pleasure spending time with you, Kelsey, and getting to meet all of your colleagues here, and we'd love to do it again sometime. And like I said, I always prefer to have people contact us at the beginning of a position, because if they're calling us at the end, that usually means something went wrong. But anyway, it's been great spending time together today.
Awesome. Thank you so much to all of you. And thank you for everybody who's stuck around. Reminder, this was from the DEI committee for the Guild. I don't know, Madonna, or if anybody else wanted to sign off, but reminder, tell everybody to join the Guild of Music Supervisors as FOG or as members. This is an example of a membership benefit. So please do it. And again, thank you so much, Aashish, Craig, and Tatiana. You guys were amazing. I learned so much. And yes, I hope I will be passing around your info.
Thank you so much. And we appreciate all the kind comments in the chat there, especially the one that said, amazing panel. I especially liked Aashish. Anyway.
Awesome. Thank you so much.
Okay. Bye-bye, guys.
Have a nice night. Bye-bye.
Bye.